Good evening, students. I am Rohit, and today we have to start with Supreme Court and High Court. Okay, so let's start the chapter. Supreme Court and High Court. Now, before starting this chapter, remember these are two chapters. Supreme Court is a different chapter and High Court is a different chapter, but we are going to study both the chapters together. Okay, because with this we can compare the Supreme Court with High Court. That is why we are starting the chapter with, we are studying both the chapters together. Okay, so before starting the Supreme Court and High Court, let us first understand the background of judiciary. I mean, when I say that we are studying Supreme Court, many students think that is this the same Supreme Court which was established in 1774 at Calcutta under the Regulating Act of 1773. So these are some questions that comes to the mind. So let me first clarify that the Supreme Court which we are studying and the Supreme Court which was established in Calcutta in 1774 are different. Now remember why. See, the government of India passed Regulating Act. The British government passed Regulating Act 1773. Okay. Now remember, we all know British government ruled for around 200 or 250 years. Now the importance of Regulating Act of 1773 was that it was the first step or first law or first step introduced by the British government to control and regulate the affairs of East India Company. The British government wanted to control the affairs of East India Company. There were rumors that the East India Company has become a corrupt company. So in order to control the affairs of the company, the British government passed the first act, that is Regulating Act of 1773. And when you will study the historical background in Indian polity, the historical background in Indian polity starts with Regulating Act of 1773. So what is the importance of this act? This was the first step, this was the step taken by the British government to control the affairs of East India Company in India. Now remember, under this act, there was a provision of establishing a Supreme Court. So under this act, in 1774, a Supreme Court was established. A Supreme Court was established in Calcutta. Okay. So this is the Supreme Court of Calcutta. But remember, today what we are studying is different from what was established in 1774. I mean, today what you see, the Supreme Court of India and the Supreme Court of Calcutta, both are different. Remember this. So finally you can see the Supreme Court was established in Calcutta in 1774. Now after a few years, by the King George III. So the King George III of Britain established Supreme Court in 1800 in Madras. And in 1823, he established Supreme Court, Bombay. So now remember, these are the three Supreme Court, these are the three first Supreme Court of India. In 1774, at Calcutta, you will find Supreme Court. Then King George III of Britain established Supreme Court in 1800 in Madras and in 1823 in Bombay. So these are three Supreme Court of that time. But what happened? After many years, in 1861, the British government passed Indian High Court Act of 1861. Now, what happened with this act? Now remember, now what we know that there are total three Supreme Courts and the British government passed Indian High Courts Act 1861. Now, under this act, there was the provision for the establishment of High Court. So, under this act, the High Court was established in 1862 at Madras, Bombay and Calcutta. Now, what we know so far that already we have seen that there were Supreme Courts in Bombay, Calcutta and Madras. So what about the High Court? Now remember, the Indian High Court Act of 1861 replaced the Supreme Court with High Court. or what we can say that the Supreme Court were abolished in Madras, Calcutta and Bombay, and in place of Supreme Court, what was established? High courts were established. So remember, in 1862, high courts were established in Madras, Calcutta and Bombay. And what happened to the Supreme Court? These Supreme Courts were abolished. So what we can say? The Act of 1861 abolished Supreme Court and established High Court in the same place. So finally in 1862, now we have High Courts of Bombay, Calcutta and Madras, and the Supreme Courts are abolished. Okay, now moving ahead. Now remember, these High Courts had the distinction of being the highest court of that time. So at that time, these were the highest court, but they were until the Federal Court of India was established in 1935. So remember, before the establishment of Federal Court, these were the highest court. But when the Federal Court was established, then the Federal Court became the highest court of India. Okay, so after the High Court, the Government of India passed, the British government passed the Government of India Act 1935. Under this act, a Federal Court was established. Now remember, when the Federal Court was established, now this Federal Court had the distinction of being the highest court of the country. Okay, now the Federal Court is above the High Courts. And remember, this Federal Court on 28th of Jan 1950 became Supreme Court of India. Became Supreme Court of India. So, our Supreme Court was inaugurated on 28th of Jan 1950, and before 28th of Jan 1950, Supreme Court was the Federal Court of India. But remember, if someone asks that which court is more powerful, the Federal Court of India or the Supreme Court of India? So remember, it is true that the Supreme Court replaced Federal Court of India, but the fact is Supreme Court of India is more powerful than the Federal Court of India. Why? Because the Supreme Court is the highest court of appeal. Federal Court cannot be considered as the highest court of appeal because the appeal against the judgment of federal courts were appealed in the Britain. Okay, so the appeal against the judgment of federal court was heard in the Britain. But in India, when it comes to Supreme Court is the highest court of appeal. There is no court above Supreme Court, or there is no authority above Supreme Court which can hear the appeal against the judgment of Supreme Court. So remember, our Supreme Court is more powerful than Federal Court because the Supreme Court is the highest court of appeal, and there is no other authority above Supreme Court which can hear the appeal against the judgment of the Supreme Court. Okay, so now you asked, sir, when did the present Supreme Court of India came into existence? As I said, the present Supreme Court of India came into existence on 28th of Jan 1950, and before 28th Jan, what it was? It was the Federal Court of India. Okay, so I hope you understood the difference between the Supreme Court and Federal Court of India. The major difference was the highest court of appeal. Okay, so this was the brief background of the Supreme Court and High Court, that initially the Supreme Courts were established in different places, and these Supreme Courts were replaced by the High Court, and these High Courts were the highest court of that time. Then Federal Court came into the picture. Federal Court became the highest court, and then this Federal Court was converted to the Supreme Court. Okay, so today we are studying the Supreme Court of India. Okay, so we are discussing the two chapters together. So on this side we will discuss the Supreme Court, and on the other side we will study the High Court. Okay, now remember, the Supreme Court of India is under Part 5th of the Constitution, and how many articles are there dealing with Supreme Court? Article 124 to 147. These articles are related to Supreme Court. Now, what about High Court? High Court is under Part 6 of the Constitution, and how many articles are there? Article 214 to 232. So these many articles are there for the High Court and these for Supreme Court. Now, how we will approach? See, the answer is simple. We will start from the basics. Basic means, first we will discuss the number of judges in Supreme Court and High Court. Then we will discuss the qualification in both the courts. Then the appointment, oath, salary, tenure, resignation, transfer, retirement. Then we will discuss the removal part. So, and once we have discussed all this, then it will be the time to discuss the jurisdiction of Supreme Court and High Court. So, before starting the strength of the judges in Supreme Court and High Court, let me first explain that Supreme Court is the highest court of appeal, which we have already discussed. Also, Supreme Court is the guarantor and defender of fundamental rights of the citizen. We also know Supreme Court is the guardian of the Constitution. So these are the basic points. I don't know whether you are, I'm not going to write all these points, but I'm just going to say that Supreme Court is the guardian of the Constitution, Supreme Court is the guarantor and defender of fundamental rights of citizen, and Supreme Court is the highest court of appeal. Also remember, Supreme Court is a self-correcting agency. The Supreme Court can review its judgment, and many times Supreme Court has done self-correction. For example, in the Berubari Union case, Supreme Court said that preamble is not a part of the Constitution. But in Kesavananda Bharati case, Supreme Court said that yes, preamble is a part of the Constitution. So Supreme Court is a self-correction agency. Okay. So first we will discuss the number of judges in Supreme Court and High Court. So let us start the strength of judges of High Court and Supreme Court. So the first thing that we are going to study is about the strength in both the court. Now remember, when we talk about the Supreme Court came into existence in 1950. In 1950, Supreme Court came into existence. And when the Supreme Court was established, at that time, there were total 7 judges and Chief Justice of Supreme Court. And we all know the Chief Justice of Supreme Court is called as the Chief Justice of India. So initially, how many judges were there? Total 8 judges were there, 7 plus 1. But at that time, the Supreme Court did not have the workload. But soon after the independence, and especially because of the population, the workload started increasing. And now it was the time to increase the strength of judges of Supreme Court. Now, we cannot expect the Supreme Court to function effectively if it has only 8 judges. So that is why with time, the strength of judges of Supreme Court was increased. Now, how it was increased? First 7, then 10 judges, then 13 judges, 17 judges, 25 judges, 30 judges, and at present we have 33 judges. So at present, what is the composition of Supreme Court? We have 33 judges and the Chief Justice of India. So together we have 34 judges in Supreme Court. 33 judges, 33 normal judges, and the one is the Chief Justice of India, that is the Supreme Court of, Chief Justice of Supreme Court. So this is the present composition or the present strength of the Supreme Court, 33 plus 1. And one more thing. Right now I discussed that with time, the strength of the judges of Supreme Court increased. Now, who was responsible for increasing the strength of judges of Supreme Court? Now, this is also an important question. If someone asks, or if this question comes in the examination, that which of the following institution has the authority to increase the number of judges of Supreme Court? So the answer is the Parliament, and that too by a law. So the Parliament by law can increase the number of judges of Supreme Court, because it doesn't make any sense to decrease the number of judges of Supreme Court, because we already know that there are crores of cases pending in the court, and if you will decrease the strength of judges of Supreme Court, then obviously the Supreme Court is not going to function effectively, and it will not be able to do justice if it has less number of judges. Okay, so obviously the Parliament with time is going to increase the number of judges of Supreme Court. So what we have to remember, other than the strength of judges of Supreme Court, we can remember that the Parliament has the authority. The Parliament has the authority. The Parliament may by law can increase the strength of the judges of Supreme Court. So this thing you have to remember, that the Parliament has the power to increase the strength of judges of Supreme Court. Now what about the strength of judges of High Court? Now remember, now here you will understand that why we are discussing this chapter, okay, these two chapters together. See, in the Constitution, it was clearly mentioned that there will be 7 judges in Supreme Court and 1 Chief Justice of India. But when it comes to High Court, there was no such number mentioned. And why? The answer is simple. There is only 1 Supreme Court in India. And that is why it was easier for the Constitution to describe that there will be 7 judges in the Supreme Court and 1 CJI. But according to Constitution, there should be a High Court in each and every state. According to Constitution, there should be a High Court in every state. So it means in all these states there will be High Court, and Now there are some high courts where the workload is more. See, for example, if we talk about Uttar Pradesh, now Uttar Pradesh has the highest population, and which is the principal high court of Uttar Pradesh? Allahabad High Court. So obviously Allahabad High Court is going to have a huge amount of workload. Why? Because it has more population. The highest population is in Uttar Pradesh. So accordingly, you will find the workload in Allahabad High Court. So don't you think that in Allahabad High Court there should be more number of judges because of the increased workload, because of because of the highest population? But what about the courts in the Northeast? In Northeast, we will find that the population is limited, so you will not find that much workload. So it is not necessary that if the number of judges in the Allahabad High Court are 100, then the same number should be in the Northeastern High Court. No, there is no need to compare. If the High Court has less work, then obviously there should be less number of judges, and if the High Court has workload, then obviously there should be more number of judges. So accordingly, the constitution, considering this fact that some high courts have workload and some high courts have little workload, so obviously in the constitution there is no mention about the strength of judges of high court. I hope you are understanding the comparison. In the constitution it is mentioned that how many judges will be there in the Supreme Court, but in the constitution it is not mentioned that how many judges will be there in the High Court, because it all depends upon the workload. So Allahabad High Court should have the highest number of judges because of the workload, whereas any other court where you will not find the same amount of workload, they will find less number of judges. So the constitution has not determined the strength of judges of High Court, and now it depends upon the president, who will determine from time to time, depending upon the workload, that how many judges should be there in a High Court. So remember, what we can write here in the strength is that the constitution has not determined. The constitution has not determined. The constitution has not determined the strength of judges of High Court. So for Supreme Court it was determined, and for High Court it was not determined. We all know the reason is workload. Now the second thing, in case of Supreme Court, the Parliament has the authority to increase the number of judges, but in case of High Court, the President has the authority to increase the number of judges. And one more thing, the Parliament will increase the strength of judges of Supreme Court by a law. I mean, by passing a law, we can increase the number of judges. But in case of High Court, we do not have to pass a law, because the power is with the President. So the President may by order can increase the number of judges of High Court. So what is going to happen here? Who is going to determine that how many judges should be there? It is the President by order. Okay. So the strength is determined. The strength is determined by the President. The strength is determined by the President from time to time. From time to time, depending upon the workload. Okay, so I hope you understood the difference, that for Supreme Court it was mentioned and for High Court it was not mentioned. The Parliament has the authority, the President has the authority. So we are finally done with the strength of the Supreme Court and High Court, and now we can start with the qualification. Okay, and remember, qualification is important because I have seen questions coming from the qualification of both Supreme Court and High Court. So let us start qualification. So on one side Supreme Court, on the other side High Court, and now let us start the qualification. Okay, so what is the qualification of a Supreme Court judge? The answer is, the first qualification of Supreme Court judge is simple, and no one is going to ask this in examination, and it is simple. You have to be a citizen of India. So no one is going to ask the first qualification, because we all know that obviously if you have to become a judge of Supreme Court, then you have to be a citizen of India. So we do not have to understand, I mean, we do not have to remember this. It is by default. Now, from here the actual qualification starts, which is also relevant for your examination. Now, being a citizen of India is important, but apart from citizen of India, what else is required? Now, the second qualification has three options: A or B or C. So the first is mandatory, and from the second point you have to choose one of the three options. Now, see, we want to choose a judge, we want to choose a person who is eligible to become a judge of Supreme Court. And for becoming a judge of Supreme Court, the basic requirement is the knowledge of law. So if a person has the knowledge of law, then we can appoint him as the judge of Supreme Court. Now we have three options. Now what should be common in all these three? The knowledge of law, because we cannot make any random person as the judge of Supreme Court. Obviously he must have the knowledge of law. Okay, so either it's A or B or C. All three should have one thing common, and that is knowledge of law. Now we have to identify those three persons who have the knowledge of law. So who could be? See, the first is simple: a judge of High Court. A judge of High Court has also a judge of High Court also has the knowledge of law. Okay, so we can choose a judge of High Court. So a High Court judge can be appointed as a judge of Supreme Court, but there should be some experience in High Court as judge. So the Constitution wants that at least for 5 years you should have been a judge of High Court, and not of a particular High Court in succession. I mean, for 2 years you worked as a judge in this High Court, then for 3 years in that High Court. Collectively it should be 5 years, not in a particular High Court. So we all know a judge of High Court has the knowledge of law, so obviously he is eligible to become a judge of Supreme Court. Now apart from judge, who else has the knowledge of law? Obviously an advocate. If the judge has the knowledge, then obviously an advocate also has the knowledge, because they both are working in the same court. So what will be the B option? The B option is an advocate of High Court. An advocate of High Court. For how many years you should have worked as an advocate? For 10 years at least. And yes, the minimum requirement is that you should be a you should be an advocate of High Court for 10 years and not in a particular High Court. Depending, for 2 years you practice in this High Court, for 5 years you practice in that High Court. So collectively it should be 10 years. And if you are an advocate in Supreme Court, then it's well and good. But at least you should be an advocate in a High Court for 10 years. So either a person who has, either a judge of High Court for 5 years or an advocate of a High Court for 10 years. Or now remember, in the starting, advocates are not the servant of the government. Those are, advocates are private and government. So are you talking about the government advocate or the private advocate? See, who is an advocate? An advocate is a person who has cleared the bar council examination. Okay, in order to fight a case in the court, you have to clear the bar council. Then only you will get the license, and then you can fight the case in the court. Before clearing the bar council exam, you are just a lawyer having a degree of LLB. See, there is a difference between a lawyer and advocate. Who is a lawyer? Whosoever has completed the LLB degree or who has the LLB degree, he is a lawyer. Okay, but he cannot fight any case in the court, because for this you have to clear the bar council exam, and then only you will get the license to practice in the court, and then he will call you as the advocate, Okay, so there is a difference between the lawyer and advocate. Okay, so yes, and definitely they are not the government servant. Only those advocate can be considered as government servant if they are government lawyer. Okay, but majority of the advocates are private, because as a private advocate you can earn a lot amount of money, but if you are government advocate, then the amount is limited. So either a judge of High Court or an advocate of a High Court. Now one more thing, what I said in the starting was that if we have to choose a person who has the knowledge of law, then we have three options. Either we can choose a judge or an advocate. Now, who else who has the knowledge of law and he is not an advocate or a judge? Then remember, he is the law professor. A law professor of a university has the knowledge of law. So he is not a judge, he is not an advocate, but he has the knowledge of law. So we can appoint a professor of law of any university as a Supreme Court judge. So it is possible according to the Constitution. However, this provision I don't think it has ever been invoked by the Supreme Court, but the fact is a law professor of a university can become a judge of Supreme Court. But in place of law professor, what it is mentioned, it is distinguished jurist, distinguished jurist in the opinion of president, in the opinion of the president. Okay, remember, the meaning of distinguished jurist is not defined, but the fact is, distinguished jurist is a person who has the knowledge of law, and definitely he is not a judge or an advocate. He is a professor of law. And in foreign countries, you will find that a law professor has been appointed as a judge of their Supreme Court or High Court. We can take example of United States of America. In USA, there have been cases where a law professor has been appointed as a judge of Supreme Court of United States. But in India, we do not see this thing happening, that a law professor is appointed as a judge of Supreme Court. But according to Constitution, it is permissible. Now, one more thing that you can notice is that I have not mentioned the age, minimum age. See, while discussing the qualification of president, vice president or governor, we discussed that the minimum age to become the president, vice president or governor is 35 years. But what about the judges of High Court? Is there no minimum age? Yes, there is no minimum age to become a judge of Supreme Court. But what is minimum is the experience. See, we are discussing about the experience. You should have at least 5 years of experience as a judge in a High Court, or at least 10 years of experience as an advocate in a High Court, or a law professor. So what is required to become a judge of Supreme Court is the experience as a judge or an advocate or as a law professor. But there is no mention about the minimum age. Now, let me tell you, if you will ask this question, or if this question comes to your mind, is there maximum age? Yes, there is maximum age, but there is no minimum age. The maximum age is 65 years. They hold office until they attain the age of 65 years, but there is no minimum age for becoming the judge of Supreme Court. Okay, so there is no mention of age. Now, let us start with the High Court. So, what is the qualification for a judge of a High Court? So, the first qualification is similar. Both should be citizen of India. Now, the second qualification, the pattern is same, but we only have two options, A or B. So, here there are total three options, A or B or C. We can choose any one of them. Now, here we will find only two options, A or B. Now, remember, we want to choose a person we have to choose a person who can become a judge of High Court. Then obviously, again, the same condition for High Court judge. It is important that that person should have the knowledge of law. Only then we can appoint him as a judge of High Court. So we have two options, A or B. And now we have to decide. So remember, if we have to choose a judge of High Court, then we can pick someone from the lower court. Yes. If a person has worked in judicial service for at least 10 years, suppose he has worked as district judge in a particular district for at least 10 years, then we can appoint him as a judge of High Court. So the first condition, the first qualification under the second point is for 10 years. He should have held a judicial office throughout the territory of India for 10 years. You can remember, consider a district judge. Okay, we can appoint a district judge as the judge of High Court. So, the first is, he should have held a judicial office for 10 years. Here, judicial office means, obviously below High Court, you will find subordinate or lower court. We are talking about those courts. Okay, or B. So, what is B? B is same. What is there for Supreme Court? The same is for High Court. So in B, you have to write the same point. An advocate of High Court for 10 years. An advocate of High Court. Advocate of High Court for 10 years. And now remember, I know there might be few students who will think that if for Supreme Court, at least 10 years in High Court was required, then for High Court, why not at least 10 years in the lower court is required? No. According to Constitution, you must have been an advocate of a High Court for 10 years. So they do not want that you should have been an advocate of a lower court for 10 years, at least you should have been an advocate of a high court for 10 years, not the lower court. So in both the case, at least an advocate of high court is required, okay, for becoming a judge of Supreme Court or High Court. But the fact is that in majority of the cases, a judge of High Court is appointed as a judge of Supreme Court. There are only few cases when an advocate is appointed as a judge, but there have been many cases where, or in majority of the cases, a judge of High Court becomes the judge of Supreme Court, okay. And I don't think it has ever been happened that a distinguished jurist has been appointed as a judge of Supreme Court. I don't think that it has ever happened. So I think we are done with the qualification of Supreme Court and High Court. And remember, in both, we will find that there is no minimum age mentioned. For Supreme Court, there is no minimum age. For High Court, there is no minimum age. But definitely there is maximum age. Okay. So we are done with the qualification. And now with the after qualification, we will start the appointment. And remember, appointment of Supreme Court and High Court judge is super important. Why? Because there have been controversies related to the appointment of the Supreme Court and High Court judge. So let us start the appointment, and remember, the appointment procedure is going to consume time, because in appointment we have to understand that what all controversies were there related to the appointment of judges of Supreme Court and High Court, because there have been always apprehensions about the interference of executive in the appointment of judges. So there were many controversies. We will understand what all happened in the 4 judges case, what constitution says about the appointment of judges, what is the role of president, what about the consultation, and the recent the step of the central government to introduce NJAC to replace the collegium system. We will examine all these issues. So let us start the appointment procedure of the judges of Supreme Court and High Court. Okay, but first let me consume water. Okay, so let us start the qualification, sorry, the appointment. Okay, so now we'll start the appointment. Okay, now remember, on this side we will discuss about the appointment of judge of Supreme Court, and on this side High Court. Okay, so we all know in Supreme Court there is the Chief Justice of India, and then there are the regular judges of Supreme Court. So in High Court we find the Chief Justice of High Court, and then there are regular judges of High Court. Okay, so first we will discuss that what is mentioned in the Constitution, what Constitution says about the appointment of judges. Okay, so let us start with the CJI, that how CJI is appointed. But remember, before I start drawing all these things, remember, the judges of Supreme Court and the judges of High Court are appointed by the President of India. See, you should not be confused that the Supreme Court is of India, and if Supreme Court is of India, then the President will appoint, and High Court is for the state, obviously the Governor will appoint, because we have the tendency to think that all the appointments in the state are done by the Governor and all the appointments at the central level are done by the President. But remember, Supreme Court and High Court both are the part of higher judiciary, and when it comes to the higher judiciary, the appointment to the higher judiciary is done by the President of India. So whether it's the Chief Justice of India or Chief Justice of High Court, normal judge of Supreme Court or normal judge of High Court, all these judges are appointed by the President of India. There is no role of Governor in the appointment procedure. But yes, the Constitution expects that there should be consultation from the Governor of the state, but in reality there is no consultation from the Governor of the state. Okay, but first let us start, and then we will see how the role of Governor comes into the picture. So first let us start with the CGI. Okay, so who will appoint the CGI? Obviously the CGI will be appointed by the President of India. So the CGI is appointed by the President of India. Okay, but we all know, while appointing, the President must consult. The President cannot appoint any person as CGI. So the President will consult from whom the President should consult. So according to the Constitution, the president while appointing the CGI should consult such judges of Supreme Court and such judges of High Court as he deems necessary. So the constitution has not mentioned that the president should take consult from how many. What the constitution has said is that the president while appointing the CGI should consult such judges of High Court and Supreme Court as he thinks necessary or as he deems fit. So there is no mention. It is simply mentioned that yes, he can consider, he can take advice from either Supreme Court or High Court or both. Now what about the judges of Supreme Court? So the judges of Supreme Court are again appointed by the president. This point will remain same, that the president is going to appoint, and again he is going to consult. So from whom he should consult while appointing the judge of Supreme Court? So the answer is he should take consultation from CGI and such judges of Supreme Court and such judges of High Court as he thinks necessary. So it means, see, while writing CGI, I never said as he thinks fit. No. To take consultation from CGI is mandatory, because for CGI, the constitution never says that it depends upon the president whether he wants to take the advice or a recommendation of CGI or not. So the advice of CGI is mandatory, and when so far these are concerned, it depends upon the president whether president wants to take the advice of Supreme Court or High Court judges. But to take the advice of CGI is definitely important for the president. President cannot ignore the advice of CGI. Okay, so the taking advice from CGI is mandatory. Now, and taking advice from Supreme Court, High Court judge, that's optional. Now, what about the Chief Justice of High Court? So again, the Chief Justice of High Court will be appointed by the President of India. He will be appointed by the President of India. And here again the President has to consult. From whom the President will consult? CGI and the Governor of the concerned state. So according to Constitution, there is a role of Governor while appointing the judges. And what is the role? The President while appointing should consult the CGI and the Governor of the concerned state. This is what Constitution expects from the President. What about the judges of Supreme Court, of High Court? So the judges of High Court are also appointed by the President. They are also appointed by the President. And again, the President should consult. Without consultation, he cannot appoint anyone. From whom he will consult? CGI, Governor of that state, and one more name, the Chief Justice of the concerned state High Court. Yes. So this is what Constitution expects from the President, from whom he should consult while appointing the judges of Supreme Court and High Court. So what we can see, other than the appointment of CGI, for all the appointments, the role of CGI is mandatory. The role of CGI is important. The CGI must give his advice whenever it is about the appointment of any judge other than the CGI. Okay, so what we can see, other than this, in all the appointments, there is a role of CGI. So the consultation from CGI is mandatory. You cannot ignore the recommendation of CGI. And now we will discuss the 4 judges cases where it was clearly established that what would be the role of CGI and what would be the status of consultation given to the President. Okay, so first you should see what I have written. Okay, so this is the appointment procedure in the Supreme Court and High Court according to Constitution. But now we will start with the reality. Now remember, first of all, let us discuss what all controversies have been there related to the appointment of judges. So remember, there was a convention in Supreme Court. From 1950 to 1973, there was a convention. Convention means it was a like parampara. Ye ek parampara thi, hai na? It was not mentioned in the Constitution. It was more or less like a parampara, and the parampara was simple. Whoever was the senior most judge of Supreme Court was appointed as the Chief Justice of India. So it was the convention. So from 1950 to 1973, the senior most judge of Supreme Court, the senior most judge of the Supreme Court was appointed as the Chief Justice of India. So in the constitution it was not mentioned. Remember, what we have seen in the constitution is that while appointing the CJI, the president will consult such judges of Supreme Court and High Court as he thinks necessary. So do you think it was mentioned in the constitution that the senior most judge of Supreme Court will be appointed as CJI? No, it was not mentioned. So that is why I am saying it was a convention that the senior most judge of Supreme Court will be appointed as the Chief Justice of India. It was a convention not mentioned in the constitution. But what happened in 1973? Why this convention existed only for 23 years? What happened after 1973? So in 1973, there was a case, and we all know about this case. It was the famous Kesavananda Bharati case. Kesavananda Bharati versus State of Kerala. And the exact date of the case was 24th of April 1973. So on this day, the judgment of this case was passed by the Supreme Court. And remember, there were total 13 judges. There was a bench of 13 judges, and out of those 13 judges, 7 judges passed a judgment which was not liked by the government. So, and these 6 judges were, these 6 judges were in the favor of government. Basically, their judgment was appreciated by the government, but their judgment was not at all liked by the government. So what happened? The story is that out of these 7 judges, I'm going to write the name of 3 judges. The first is not definitely in sequence, but J.M. Shelat, K.S. Hegde, and A.N. Grover. Okay, so out of these 7 judges, I have written the name of 3 judges, and from here I will write the name of 1 judge, and that is Ajit Nath Ray. Now, why we have written the name of these 4 judges out of 13? The answer is, see, from 1950 to 1973, there was a convention that the senior most judge of Supreme Court will be appointed as CJI. So, who should be the next CJI? Obviously, a senior most judge of Supreme Court. Now remember, these 3 were the 3 senior most judges of Supreme Court. So ideally, anyone from them should have become the Chief Justice of India, because these were the 3 senior most judges of the Supreme Court. And why I have written his name? Because he was the 4th senior most judge of Supreme Court. But what happened? The Indira Gandhi government advised the President of India that you appoint Ajit Nath Ray as the CJI. Now here the government ignored the convention. The convention was to appoint the senior most as the CJI. So ideally, it should have been J.M. Shelat or K.S. Hegde or A.N. Grover, but these 3 senior most judges were superseded, and Ajit Nath Ray was appointed as the CJI of India. So this was for the first time that the 4th senior most judge of the Supreme Court was appointed as the CJI was appointed as the CJI. So Ajit Nath Ray, being 4th in the seniority, was appointed as the CJI. Okay. So what happened? Consequently, they resigned because it was a humiliation that their junior has been appointed as the Chief Justice of India. So what we can see that the convention, the government broke the convention, and what we have seen the consequence. So this was a clear symbol. This was a clear signal to the judiciary. The signal is clear that if you try to pass a judgment which is not in the favor of government, then definitely the government is going to take these actions. Okay, see, it is not possible for the government to remove a judge because it is a difficult procedure. So far, no judge of the Supreme Court or High Court has been removed. So you can imagine the process is tough. Okay, a special majority is required, and it is not easy to achieve a special majority in the parliament. Okay, especially when the parliament is divided. The parties are divided. Okay, so it is not possible for the government to remove a judge. Okay, how will prove the charge? Just because a judge has given a judgment which the government doesn't like, it doesn't mean that the government can remove a judge. So definitely, removing a judge is not an option. Then you cannot transfer a judge of Supreme Court because there is only one Supreme Court in India and there is no other Supreme Court. So obviously you cannot transfer a judge of Supreme Court. Definitely you can transfer a judge of High Court, but there is no provision for the transfer of Supreme Court judge. Okay, so we cannot transfer a judge of Supreme Court, we cannot remove them, and we cannot stop their salary because their salary is charged upon the Consolidated Fund of India. And since it is charged upon the Consolidated Fund of India, you cannot stop their salary unless it is the financial emergency in the country. Okay, so what else the government could do? What government did? The government tried to harass judge by sending a signal, that is, we have appointed a junior as the CGI just because you passed a judgment which was not appreciated by us. So this was the first signal given by the government. Now there will be another signal by the government. Now wait for that signal. Now that signal came after a few years. It was the case ADM Jabalpur versus Shivkant Shukla case of 1977. I might be confused whether it's 1977 or 1978, but I think it's 1977. Okay, so in ADM Jabalpur case, this was a case during emergency. Now, in this case, a total 5-judge bench was constituted, and in this 5-judge bench, 4 judges passed a judgment which was in the favor of government. What they passed, they said that the right to life can be taken even during an emergency. So if the government has imposed national emergency, for example, then it will be possible for the government to take the right to life of its people. So the right to life can be taken even during emergency. But there was one judge who had the courage to stand against the government, and he was HR Khanna. So HR Khanna said that even if it is an emergency, the government has no right to take the right to life. Okay, so right to life will remain even during the emergency. But for them, for these 4 judges, right to life can be taken even during emergency. So this should be considered a bad judgment. Okay, we cannot expect from the judiciary to say that now the government has imposed emergency, and in the name of emergency, the government can pass any random law, and with that random law, your life can be taken. No, we cannot expect this from judiciary, and that is why it can be considered as the darkest phase of Indian judiciary. When obviously judiciary said that you can take the right to life of a citizen during emergency, then obviously it was the darkest phase of the judiciary. So now what happened? What was the consequence of this judgment? The consequence was that HR Khanna was to be appointed as the CGI. He was next in line to become the CGI, but his junior, who was sitting in these 4, he was MU Beg. So MU Beg, because of his judgment, he was appointed as the CGI. So MU Beg became the CGI, whereas HR Khanna resigned, obviously, because this can be seen as a humiliation. Okay, so what happened? These 2 cases are enough to show that what government is ready to do if you are not going to pass the judgment in its favor. So now from here, the controversy over consultation erupts. So now we will discuss that what is the controversy over consultation. But I hope these 2 cases are clear. I hope you understood that what was the convention for the past 23 years from 1950 to 1973, and how the government tried to break this convention by appointing a junior judge of Supreme Court as the CGI, and the same happened after the ADM Jabalpur case. Okay, so these were the 2 important cases related to appointment, controversy related to appointment. So with this, we will start the topic controversy over consultation, because we all know that while appointing a judge of Supreme Court or High Court, what is required? Consultation. Now we all know what exactly consultation is. We all have taken consultation from doctor. In the whenever you consult a doctor, in front of his office or clinic, it is mentioned the consultation fee is 2,000 rupees, the consultation fees is 3,000 rupees. Okay, so whenever you take consultation from a doctor, do you think you are going to you are going to follow all the advices of doctor? No, we have just taken consultation from the doctor. We are not going to follow all the advices. Many times we have seen doctors saying that, okay, you do this test, you do that test, and we all know what the doctor is trying to do. He's just trying to make the bill. Okay, so that's why if we have taken consultation from doctor, then it is not at all necessary that we have to follow the advice of doctor because it was the consultation. Now the same question is that according to constitution, the president has to consult the judiciary while appointing the judges. So is it necessary for the president to follow the advice given by the CGI? So what is the exact meaning of the word consultation? This we have to understand. So that is why now we will start the controversy over consultation. Controversy over consultation. And now you know why there is controversy over consultation, because we really want to understand that what is the meaning of the word consultation. And now remember, in this we will study these 4 cases. First judge's case of 1982, the second judge's case of 1993, the third judge's case of 1998, and the fourth and the final judge's case till now, fourth judge's case of 2015. So in these 4 judges case, we will definitely understand that what is the status of consultation, what is the status of the advice given by the CGI, and from whom the president should consult, how many judges should be there while consulting. And we will also understand the collegium, the role of collegium, and what happened with NJC. NJC was the step by the government to replace collegium. So all these things will be discussed in the next class. So today we are done. Okay, so in the next class, that is tomorrow, we will be starting with the controversy over consultation. So tomorrow is the second part of Supreme Court and High Court, and then we will study the 4 judges case. And once those 4 judges case are over, we will study the small details: oath, resignation, salary, transfer, tenure. Then the important part will come, the removal of a Supreme Court and High Court judge. That is important for you. Okay, and then the jurisdiction of Supreme Court and High Court. Okay, so all these things will be discussed in the next class, that is tomorrow, same timing, 8:30 to 9:30. I'm about to change the timing of the class, but obviously because of some reasons I was not able to change the class, and that is why I will be taking the class from 8:30 to 9:30. Okay, so I hope you understood whatever I was saying. So all those who are there, kindly reply whether you understood whatever we have discussed so far. Did you understand the controversy associated, why there is a controversy, what constitution says about the appointment procedure, what is the qualification, the strength of judges, and the brief background discussed in the beginning. Okay, so all those who are listening, respond whether you understood or not. I usually do not ask this question because usually students are not there. Okay, they watch this video but only after some time. No, definitely not in the live class. So if anyone is there, yes, tell me now whether you understood or not. Okay, so okay, so then goodbye, we'll meet tomorrow. Okay, so bye everyone.